Hello and welcome to today's webinar. My name is Robbie and I will be in the background answering any WebEx technical questions. We have a few housekeeping items before we get started. If you experience technical difficulties joining the WebEx session, please dial 1-866-779-3239 or you can message the WebEx producer using the Q&A panel. During the presentation, all participants will remain in a listen-only mode, and as a reminder, this event is being recorded. I would now like to hand it off to your first speaker for today, Grant Dredges. Grant, you now have the floor.
Thanks, Robbie. Before we get into the substance of the presentation, I would like to let everyone know that all registrants will receive an email from MBHB within 24 to 48 hours. It'll have a PDF copy of the PowerPoint that we're going through this morning, as well as a link to an archived audio version of today's presentation. I'd also like to warn you, for those of you who are seeking CLE credit, that you will have to make sure you look for and address the two randomly placed PowerPoint slides that we put in discrete sections of the presentation, inviting participants to complete a simple online poll question. You have to complete both poll questions in order to confirm that you're an active participant and thus be eligible for CLE credit. We encourage you at the end during the presentation, for that matter, to submit any questions you may have regarding the webinar presentation. There's a WebEx online question submission module at the right of your screen. Time permitting, we're going to attempt to address submitted questions at the end of the webinar. If time doesn't permit, we'll respond offline after the webinar. Thank you and good morning. So, Jason Cray and I have spent a lot of time working in product clearances, landscaping, and product opinions of counsel, and thought for the in-house counsel among you that it would be good to go over some guidelines for you and your business, risk issues that you should consider, as well as approaches that you as in-house counsel can take with the business side to get them to understand the need for prospective IP management. We're going to be going through both about when and how you should look at reducing your company's risks, search strategies we found that have worked to help with doing just that, and then opinions of counsel and best practices for such opinions, among other things. So with respect to reducing your company's risks, I'd like you all to think for a moment about what situations place your company at the most risk of developing potential patent infringement liability. In my law school class, I'd be asking you to play Jeopardy and respond with questions for me, but unfortunately everyone here is muted, so I'm going to be stuck giving you the answers. There's a whole lot. The simple question is there's quite a number of milestones where you have to think about assessing what risks you may have regarding infringement of IP. If you don't head off those risks, they could cause self-inflicted wounds. Accusations of patent infringement can come from many quarters, either competitors, universities, solo inventors, and of course, in today's day and age, NPEs, non-practicing entities, also known as patent trolls, are a very significant risk. I'm going to go over these situations and talk about what steps you should consider in each of them, and really what are the best practices you should think about. So with respect to early and next generation product development, if your company's just beginning the process at this stage or at some stage, developing a next generation product or a new product altogether, you really should consider a patent landscape analysis. It's a broad review of the art, includes U.S. and foreign references usually. It can include scientific and marketing literature, although your own in-house engineers may well be more familiar with that, and marketing folks may be more familiar with that type of material than they often are with patent art. An attorney, though, conducting a landscape analysis can be really useful in identifying not only problems but also opportunities. It can help you clear roadblocks, propose some design around options, consider licensing targeted IP that would help in your development process, and help look for white space, basically technology areas where you appear to have an open playing field. By looking at newly published applications of your competitors also, A landscape analysis can give you an idea of what development directions they may be pursuing and really give you competitive intelligence ultimately. Now, there are several software programs that purport to give you visuals of patent landscapes, and they can be useful in some respects, but they are really kind of light on the actual analysis portion. It's more a visualization kind of approach. So I generally haven't found them to be terribly useful in the landscaping process overall. And to be productive, landscape searches really require that whoever's conducting them have a detailed understanding of your product lines as well as your product goals. And really, it has to be done in close cooperation with your development team. With that, an early landscape analysis can help guide your future development and really reduce your overall long-term patent risks and costs. When, however, you've got the product design somewhat more nailed down, although preferably not finalized, and the folks are further along the design path, it's really important for you to take a focused look at those product features that have, in fact, worked their way into your current design and provide a freedom to operate, an FTO, to make sure that you aren't running afoul of any issued patents. The concern here is, once again, making sure that your patent counsel is closely aligned with your product development team, because each new product could have literally 20, 30, or 40 or more features, and determining which of those are worth pursuing in connection with an FTO, which of them are routine enough that they really don't have to be considered in connection with an FTO. Weeding through all of that in order to determine which should be analyzed requires some back and forth with your engineers, as well as some significant understanding by the attorney as far as what your product approach is in the industry. When the attorney comes across patents that do appear to be a problem, again, one of the reasons to have someone who is very familiar with your product line and the industry is that you want them to be familiar enough with the art to be able to really give you an initial assessment of the validity of the patent, as well as a game plan for getting past it, whether it's proposing workarounds, whether it's an opinion, whether it's even an affirmative step towards invalidation if it's a significant enough problem. You really want to have a game plan, and that's something that again, having counsel who's familiar with your industry, familiar with your product line, is very important. By doing so, with respect to a freedom to operate, the whole goal is to reduce long-term redesign costs. The risk of finding an infringement after you've finalized your product and then all of a sudden have to take several steps backwards, and ultimately to reduce your long-term patent risks. And the one other aspect I will note is that it's important to realize that freedom to operate, again, is best served when you're in the process of working through the design, but it's really important to go back at the end of the day and make sure that you've captured all features that ultimately work their way into the final product. Oftentimes there'll be some later revisions, and without making sure that you have the conversation between your patent attorney and your developers to make sure that they really understand what's worked their way into the final product, you can end up with problems and out-of-date searches that just aren't that useful and present risks. Another issue yet, of course, is third-party IP. And competitors' patents and PE's patents obviously present the greatest risk. Now, in connection with this, the most proactive thing, obviously, is monitoring competitors' IP in particular. And what you may find is that there's actually, in some situations, we've had significant findings where competitors' IP has been crafted to read specifically on our clients' products, and some explicitly, some not so explicitly. And there's also a risk that they're considering potentially leapfrogging your own current technology and trying to develop IP that hems you in the future, even beyond your current product line. And so it's keeping abreast of that, looking at what approaches your competitors are taking. It may just be that they're pursuing some parallel development paths, and it's a pure coincidence. But oftentimes you'll find that it's not. And even NPEs now have gotten very much into the approach of strategic prosecution and strategic amendments in pending applications to really focus their patents on specific products of several of our clients, and taking a look at those, trying to monitor what directions they're taking as well can become a very important way of mitigating risk. If serious enough, of course, you may consider a challenge, and that highlights why monitoring is important. With respect to newly issued patents, you have a 9-month window to file a post-grant review if it's really a significant enough problem. And unless you keep abreast of that 9-month period of when applications are issuing as patents, you're not going to be able to necessarily stay within that window. And of course, PGRs are the patent office procedure that give you the broadest approach to invalidating patents. You can cover 101 issues, Section 112 issues, really any validity issue except for double patenting can be addressed in a post-grant review. IPRs, like ex parte reexaminations, are going to be a lot more limited, directed specifically to published materials, including patents. So in any event, monitoring IP, newly issued IP in particular, is very important in that regard. To the extent that Europe is a big market for you, recognize Europe has the exact same types of time constraints. Oppositions there can only be filed within 9 months after issuance, just like PGRs here in the U.S. So if Europe is an important market, it's important to keep abreast of that, because after that period expires, you're stuck filing invalidation procedures in every country where the patentee has validated the European patent, at least for now, until we have a unified patent court. But for now, it's a significant issue. So beyond monitoring their actual patent portfolios and newly issued IP in particular, it's also worthwhile monitoring litigation, both competitor litigation and, of course, NPE litigation. That, too, helps you identify what risks there are for you. Your head may be the next on the chopping block, and it also allows you to start identifying ways to try to ameliorate that risk. Obviously, identifying non-infringement arguments and trying to develop, having your engineers develop non-infringing alternatives, or at least begin thinking about what kind of non-infringing alternatives they may consider if you are indeed the next on the chopping block. And it also allows you to start putting together relevant prior art and evidence of your own prior use and sales if you've got it. I've been told a number of times by clients, we're not worried about it. It's something that we've been doing for 20 years. That their patent can't be valid. I don't understand why we need to take any steps beyond it. Well, the problem is, of course, you can't just rely on testimony that we've been doing it for 20 years to support a patent invalidation. You have to have corroborating evidence. You have to find notebooks, sales materials, evidence of the prior use that will corroborate testimony. And so collecting that type of material is something that is well worthwhile to try to reduce your long-term risk. Of course, in those kinds of situations, you also want to consider an opinion of counsel because, again, by the time a patent is proceeded to litigation, that means there is a very significant risk for you and your company. And then, of course, it's worth figuring out whether you have enough prior art that you can consider either an IPR or, if timely, a PGR. Another risk point is either you or your customers receiving a cease and desist letter or a third party is offered a license. For all intents and purposes, those have to be treated as the same. And offered a license is often just nothing more than a watered-down threat of infringement. So here, too, you have to take a look at what your non-infringement and validity arguments are, what your potential defenses are. Getting patent counsel involved to do that is well worth it. Consider an opinion of counsel. That's yet another approach that is something that is, it's better than not at all. And it certainly, as we're going to discuss, the timing of opinions of counsel can be an important criteria as far as how viable they are as far as providing a defense to things like willful infringement or inducement. And in some cases where you feel that litigation is extremely likely, you may want to consider taking the offensive, possibly filing a declaratory judgment action in order to try to get the forum of your choice, one that maybe is a little bit more anti-patent. There's still forum shopping out there, particularly for DJ actions. But you have to recognize that filing a DJ action does restrict your ability to file an IPR under the American Invents Act. And so, obviously you'll need to talk with your counsel about what those risks are and whether, whether the disadvantage that a DJ action provides with respect to filing an IPR is worth it or not. Yet another time or series of issues that may come up that should alert you to the potential need for considering what your risks are regarding infringement is any kind of assertion admission of copying. And that's not necessarily just a competitor accusing you of copying. That's even your own internal people saying, hey, we really like this feature that X company's got in their product, and we want to put it on ours. Whenever you hear that, it should start some sirens going in your head. Obviously, if the product's got any kind of notice, marking notice, that presents even more issues. In fact, one of the leading Supreme Court cases on inducement, Global Tech Appliances, which we'll talk about a little bit more later, involved a company that was knocked off a competitive product that had a patent marking notice on it. And as a result, the court found that such copying constituted willful blindness that supported an inducement charge and, of course, would be very likely to support a willful infringement charge as well. If you get a request for a customer in negotiating a supply agreement for an indemnification provision, that's yet another situation where you should really take a look at what that is doing with respect to your potential risks, because you're obviously accepting their risks on top of your own. You have to look at how they're marketing the product. Are they taking any actions that present new inducement or contributory infringement issues regarding how they're selling the product that you haven't already explored? You have to look at what countries they're selling the product in and whether you've cleared the product in those countries. So you really have to, again, take a whole nother level of steps when you are faced with potential assertions of copying or find your competitor's marking, or you asked to sign a customer indemnification agreement. All right. Well, I warned you that there were going to be a number of slides in here, that there are 2 slides that require you to submit an answer to in the polling question, or in a word in the polling box off to the side of your screen. This is the first of them. If you're planning on getting CLE credit, you're going to have to put the word opinion into the WebEx poll box on the right of your screen. I'll leave it up here for just a few minutes, or a minute or so. And in the meantime, I am going. Oh, and please, when you put the word opinion in there, make sure you hit submit at the bottom right of your screen, because that is a problem that we've apparently had in the past. And with that, I'll turn it over to Jason to talk a little bit about search strategies.
Thanks, Grant. So in this next section, we're going to talk about some patent search strategies and some best practices. As Grant mentioned, there's a few different types of patent searches that may be performed. Each of these different types of searches has different objectives, and so the scope of the searches will generally vary. I'm going to switch over now here. So on this slide here, you can see some of the different types of searches. I'll go through them real briefly. We're going to primarily focus on FTO and freedom to operate searches, but some of the strategies we'll talk about can be applied to these other types of searches as well. So a patentability search is generally conducted to evaluate whether an invention is likely to be patentable. As you can see here on the slide, you're really going to look in quite a few different places. You're really looking for anything that might be material to a patent office's decision whether to grant your patent. So you might look at active patents, expired patents, published patent applications, and maybe even non-patent literature, which is scientific papers and technical documents, marketing materials, if you really want to be excessive. So another type of search, as Grant mentioned, is landscape search, and this is conducted to evaluate the state of the art, identify white space, etc. Again, you're looking really at everything that's come before, so you're going to look in similar places that you did for the patentability search, as you can see there. The next 2, competitor monitoring and freedom to operate. These are a little different. Here, you're searching to identify potential patent infringement risks. So here, we're going to focus the search on active patents and patent applications that may ultimately become patents. So unlike the others, here we're just focused on patents and applications that may ultimately present a risk of potential patent infringement. The last type of search is an invalidity search, and typically this is performed in the context of a freedom to operate analysis or study. Generally, you'll do the freedom to operate search first. You'll evaluate potential infringement risk. If you find a patent that presents a particular problem for infringement, you may consider whether that patent is actually invalid. And then to do that, you'll do a search looking for prior art relative to that patent. So again, you'll look in all the different potential sources for patents, active patents, expired patents, applications, non-patent literature. Okay, so as I mentioned, we're going to focus primarily on freedom to operate searches and studies, but many of the concepts we're going to discuss can be applied to the other types of searches and studies. For example, regardless of the type of search that you're considering, you really should develop a well-thought-out plan before you start. And on this slide, what you see here is an example plan for a freedom to operate analysis. I'm going to go through each of these steps in the following slides, but for now, I just wanted to note that several of these steps involve a relatively high degree amount of collaboration between the searcher or the attorney and the business folks, the product developers, in-house counsel. And developing a well-thought-out plan before you start to search can significantly reduce the burden on all those folks and really allow them to focus on, developing the products and doing their normal day-to-day activities. It can also make the search a lot more efficient and provide a much better quality of search where you're going to be able to identify references that are more likely to, be relevant to potential patent infringement. Okay, so the first step in the process is to gather the facts. If it's hard to conduct a search when you don't know what you're searching for, right? The better the searcher understands the product, the more likely it is that the searcher is going to identify relevant patents and applications. So on this slide, you can see here's a few things that you should consider doing. Identify the best available product descriptions and the primary developers. You may already have some documentation. If the product is farther along in development, there might be quite a bit of documentation. If not, there may not be as much, but that's where the developers come in. It's very helpful to have conversations prior to the search to have any questions answered before you conduct the search. Again, this is going to help provide a much higher quality search, a much more efficient search, and really reduce a lot of the back-end analysis and collaboration with the business folks on the back end. Okay, you want to assess the stage of development. If the product's at an early stage of development, some features may not yet be finalized, so you may have to account for some different options. By contrast, if you're at a later stage of development or it's already been commercialized, there may be very well-defined features, and you may be able to narrow your search to focus on the narrow ways of implementing a particular feature. You should consider which components are new or clearly visible to the public. As Grant mentioned, products typically have many, many features, but we live in a world of finite resources, and we need to make decisions about which features we're going to prioritize for a search. New features and visible features generally present a higher risk than old features or hard-to-detect features. So, if there's a feature that's been around for more than 20 years, it's unlikely that there's a patent, or less likely, I should say, that there's a patent that's directed to that particular feature. Harder to detect features, the people who are making determinations whether they're going to sue you for patent infringement are going to analyze your products. If they can't tell if you have a feature or not, that type of feature might present a little bit lower risk of potential infringement liability, and you may choose not to emphasize that as much in your searches. I'll take these next two together, but you might consider, are there any components subject to existing patent licenses, or are there any components that were developed by your suppliers, and you might have indemnification clauses with respect to those components. There's a few things here. One, these types of things might suggest that there's some additional source of information about how a feature might work. So if you have a patent that you're licensing, you might look at the patent to see how they describe how a feature might work. Similarly, you might reach out to your supplier to get additional information about a feature if the client doesn't know something that you might be pertinent to the analysis. The other thing I want to mention here is that the existence of a patent license or an indemnification clause might also suggest that the feature may present a lower risk of potential liability. And I say lower, not no risk, because there certainly is some risk associated with these types of situations. If you have a license to a patent, that patent has a claim scope, and it may cover the component, but someone else may have another patent with overlapping claim scope or narrower claim scope, and just because you can practice the broader concept doesn't necessarily mean that you can practice the narrower claim scope. So that doesn't mean there's no risk, and you should still consider doing searches directed to these types of components. Somewhat similar with indemnification clauses. They're nice to have, but there can be scenarios where it may be difficult to enforce your indemnification clause. One example might be if you have a foreign supplier, it may be difficult to enforce the indemnification clause against them if they're in a foreign country. Lastly, what you may want to consider is whether the product or service is going to vary from country to country. If you're going to do a search in different countries, you need to know which features to search in those countries. Okay, once we understand the product, now we can create a search strategy. Part of that strategy needs to be where to search. So it might just be the United States, it might be some other countries. But what you really want to be thinking about here is where is the potential risk for patent infringement. So in other words, where are you going to make, use, or sell your product? Now, again, we live in a world of finite resources. You may not be able to search everywhere. So you may pick one jurisdiction or another. Oftentimes, it's just the United States. I will mention, though, that doing a search in one jurisdiction can be beneficial to evaluate risk in other jurisdictions because the references you identify may have foreign counterparts in those other jurisdictions. Okay, so we also want to identify the primary competitors. As Grant mentioned, these are the people that are most likely to sue you for patent infringement. These are likely going to create the greatest risk for you. They have the most to lose by you having your products on the market. And then the last thing for creating a search strategy, you want to develop a list of search terms based on really everything you did in the prior step. The product descriptions, discussing with the developers, marketing materials. And if there's any other patents that you're already aware of, you'll want to consider those as well. Okay, once you've created your search strategy, now it's time to execute it. There's several different ways that you can search for patents and applications, but in general, you'll want to use a multi-pronged approach, which might include word searching, classification searching, competitor searching. Word searching generally uses keywords, so these are the search terminology you developed earlier in the process, and you can do some searches with those. Classification search allows you to search or filter by subject matter or technology area, regardless of the terminology used. So this might help you to capture some references that uses terminology that you didn't anticipate. So that can be helpful to catch some things that you might have missed in the earlier stages of the process. And then competitor searching, again, competitors present the greatest risk. You want to make sure that your search results include at least the patents in their portfolios. So what you can do is you can search based on assignee or applicant fields, and that generally pulls up references in the patent portfolios of your competitors. Now, another strategy that you can employ that is pretty powerful in identifying relevant references is what's known as forward and backward searching. And this strategy takes advantage of the fact that U.S. patents include citations to other patents and applications. So as a part of the prosecution process, an examiner might cite references against a patent or the application at the time, or the applicant might cite references in an information disclosure statement that might be material to the claims of that patent. And this all just suggests that whatever is cited in a patent is likely to be relevant to the claims in the patent that you've already identified as being of interest. So you can use those citations to identify other highly relevant references. I'll take these out of order, but backward citations looks backwards in time. So if you start with your reference that you've identified, if you look at the references that were cited against it or during prosecution, that's your backwards references. Forward citations look forward in time. So if there's another patent that comes along later that cites your patent of interest will appear in the file history of that patent, and you can search that way to find those references. Typically, using the forward and backward searching techniques tends to be a pretty iterative process. You identify one of interest, forward and backward search identifies others. You do forward and backward searching on those, and so on and so forth. But that is one of the best ways to find highly relevant references. Okay, here's a few tips for searching. One thing I like to do is identify some references that I know should appear in my search results. I use this as a little bit of a quality control metric. So I run some searches, take a look at the results. If I don't see references that I think should be there, that I previously identified, I'll reevaluate my search criteria and see why they're not there. Another tip, when you're doing a search at some point, you got to figure out when to stop. And one indication that can be helpful is when further searches are only turning up references you've already considered. Now, it's really just an indication. It's not a hard and fast rule. You want to make sure that your searches are diversified sufficiently so that you're not just seeing references because you didn't do a good job putting your search strings together. But once you start seeing the same references over and over again, it's a good indication that you've probably exhausted your search. Something else you could try, some tools that are out there, Google Patents, Inography, have some features that take advantage of artificial intelligence to identify references that may be similar to a reference of interest, so you could try those. For some technology areas, those are great, and others, they're a little less successful. And then lastly, one tip, whenever you identify a close reference, you should always check to determine whether the patent family is open. And in particular, you got to make sure that there's you want to make sure that, or determine whether there's any unpublished applications, because unpublished applications will not turn up in your search results. So you want to go into PAIR if you're looking in the U.S., and you want to look at the continuity tab, and you want to flag those. And those are the types of situations where then you want to sort of check on those as they progress through the patent office and keep an eye on those. Okay, so as we conduct our searches, we're going to need to analyze the patents and the applications that we find. And what we're really doing here is evaluating the risk of potential patent infringement for each patent that we identify. So how do you do that? You compare the claims to the product and determine whether the product arguably includes all the limitations of a claim. Or if the limitation is missing, you should consider whether there's some equivalent of that limitation in the product. So this is a non-infringement analysis in this first pass. And in practice, what you'll find is some patents present no or very low risk of infringement. For example, your product may have no limitations from a patent. But on the other end of the spectrum, there'll be some patents that present a very high risk of infringement. And maybe a lot of the limitations for a given claim can be found in your product or arguably are contained in your product. And that's on the other end of the spectrum. But then most often you'll find that most of the references you consider fall somewhere in between, or many of them will fall in between those two extremes. And so what we'll want to do is develop a system to group or rank the patents and applications that we are looking at. And the reason we do this is you generally can't prepare an opinion or take some action on everything you identify. So we need to prioritize our resources and focus on the greatest risks. And now when we say group or rank by potential risk, we certainly want to take into consideration the analysis that I was just talking about, looking at the claims relative to the product. But you might also take into consideration some other factors. For example, how much patent term is left on a given patent, whether a patent was previously litigated, whether the S&E is particularly litigious, whether they're a direct competitor. So your ranking system may take into consideration more factors that may provide some indication of the potential risk for patent infringement litigation. Also, as a result of this is now, once you've done that, this is the point in the process where you'll want to get back together with the business folks, the product developers, and in-house counsel to talk through any additional information that may be needed. There may be some patents that you identify that you're just not sure about a particular technical feature, and you may need some more information. So this is an opportunity to do that. But you'll also want to talk about the groupings and the rankings and the potential risk assessment that you've identified based on your analysis. And as a result of that, what you'll end up doing is you'll make some decisions about how you're going to deal with third-party patents that may present a risk. And so as you can see here, there's a few different options for how you might respond to a potential risk. You might license the patent. You might design around. Those are great options if you're early in product development. You could still do them if you're later in product development. There's just a little trickier to do those. Perhaps you do a next-gen product with a design around. Alternatively, or in addition, you can obtain an opinion of counsel, and we're going to spend quite a bit of time in the rest of the presentation talking about opinions of counsel. And then the final option is you could just abandon the product, and that's certainly one way to mitigate the risk, but oftentimes not the preferred way. So with that, I'll turn it back over to Grant to talk more about opinions of counsel.
Thanks, Jason. And before we do, there's a few questions which have come up, and there's a couple that I thought were interesting. One, someone asked about specific searching capabilities that are available to practitioners. Jason already mentioned Google Patents and Inography. There's certainly the Patent Office database as well, which of patents and published applications, databases, I should say, which can be pretty powerful as well. Google Patents is very good, but it has its limitations. In particular, if you look at recently issued patents, Google Patents seems to take a little while to get those up and online. So your search will miss those. It's important to take a look back at the U.S. Patent Office database before you conclude a search in that regard. And we did actually a comparison of the two, just to give folks an idea of what to expect or what risks there are with respect to using either the Patent Office database or or Google Patents as examples. And that's going to be in some resource materials that we'll have at the end of the presentation for the handouts, but we're not going to go through them, unfortunately, here. We also went through a few other options of types of databases that are available, most of them for a charge, unlike the Google Patents and the U.S. Patent Office database. Another question that we had, someone asked about the risks of landscape FTOs and monitoring as far as potentially creating a willfulness problem and a technical problem as far as making sure you get relevant patents on IDSs if you're also doing prosecution. And Jason, you may have thoughts about this, and by all means, you can add to your thoughts if you'd like. But my thought with respect to that kind of issue is, if you don't do it, you're potentially burying your head in the sand. And yes, it may help avoid a willfulness charge later on if you don't become aware of a patent. But if it is a significant patent and it's a significant roadblock, the costs later on, and we're going to get into it very shortly, of potential infringement finding, of injunction, of filing an IPR if you're locked into the design and you can't work around it, of redesigning your product. Those kinds of costs are far more significant down the road than they can be by early management. But any other thoughts, Jason?
Yeah, no, I agree. I think certainly becoming aware of a problem allows you to then address it. And as you can see on the slide, there are several ways that you can do that. It also depends on where you're at in the life cycle of a product. If you're in early stages of product development, you certainly have a lot of options for how you deal with it. But even if you're later on, you still have all these options, including obtaining an opinion of counsel, which can help you to mitigate the risk.
And as far as the technical problem of making sure you get references on IDSs, that's really a record-keeping issue, and making sure that whoever's doing the searching is coordinating with whoever's doing the prosecution in a way that relevant references get cited to the Patent Office. And again, you're going to want to do that to make sure that you've got a viable patent property when you're done with prosecution. So in any event. So I would like to switch to opinions of counsel here and talk a little bit about the when and why. Let me start with a strong caveat, and that is a legal opinion required? Absolutely not. The Section 298 enacted in 2011 made this pretty darn clear, that the failure of an infringer to obtain advice of counsel can't be used to prove that the accused infringer willfully infringed the patent or that the infringer intended to induce infringement of the patent. And if that's not enough, the Federal Circuit just last year, in addressing just this issue, found that in that case, the defendant's decision not to seek an advice of counsel defense is legally irrelevant under 35 U.S.C. Section 298. So why do it? Well, because consulting with counsel and handling these issues prospectively will reduce your risk. Opinions of counsel and patent clearance procedures are certainly not required, but they, if they're supported with good faith, competent arguments, the opinion in particular, they end up really having several roles. First, even as to willful infringement and inducement, they go a long way to establishing good faith. They're not necessary, but they may well be sufficient. And then, as you noted, getting counsel involved early and as soon as possible can help identify those infringement problems early and avoid, maybe take steps to avoid them in the design. They allow time for design around if a problem can't be solved any other way, and they identify and allow you to identify and maintain evidence of invalidity if that's the route that you're going to be going. So let's kind of go through what the risks are for infringement, and it's one of the reasons why I raised that question that, in particular, in the middle here that somebody had raised. The risk of keeping your head in the sand can lead to an infringement charge that you don't expect. And from that perspective, obviously there's damages, risk of an injunction, risk of being found liable for inducement or contributory infringement. If you're not getting an opinion of counsel, once you do become aware of a patent, the damages of treble damages up to treble damages and enhanced damages, the risk of paying attorney's fees, and of course, not to mention your own litigation costs, your own attorney's fees. So I'm going to go through some of these in some more detail. I'm not going to address profits overall, damages overall. I mean, that could take hours of webinar time in and of itself. But, it is worth mentioning that there's really two measures of damages. Lost profits is the plaintiff's preferred approach if they can do it. Non-practicing entities have a tough time with it. Their damages are limited by what they would have licensed the product for, which ends up being typically equivalent to a reasonable royalty. But clearly lost profits are the real risk here. And they're a risk not just because they end up being more significantly more than a reasonable royalty, but they're also a risk, as you see in the pharma area, where the patentee's lost profits may well exceed the infringer's revenues. And so it presents a much bigger risk than an outside risk, let's put it that way. And for practicing entities, there was a recent PricewaterhouseCoopers patent study that looked at how often practicing entities end up getting lost profits versus reasonable royalties. And in fact, lost profits plays a role in 2 out of 5 cases where damages are found. Either lost profits only, 21%, or a mix of lost profits and reasonable royalties was an additional 19%, and with reasonable royalties being awarded in 60% of the cases because the plaintiff couldn't prove up the elements requiring lost profits, the but-for standard that's set out in Panduit. So, obviously damages are a risk. Injunctions, both preliminary and permanent injunctions, are also a very real risk. In connection with this, taking a look at some of the data from Docket Navigator on success rates for preliminary injunctions, I thought it'd be interesting to see. Generally, it varies over the last 10 to 15 years between 17 and 25% success rate for preliminary injunctions. Higher yet in the case of biotech and organic chemistry cases, up to 32%. Now, there were a couple factors that people expected would significantly affect the ability to get injunctions. And for preliminary injunctions in particular, there was some thought that the availability of IPRs under the AIA might significantly affect someone's ability to get a preliminary injunction. It really hasn't panned out that way. We have found a half a dozen cases where a pending IPR was cited as grounds for denying a preliminary injunction, but even there, many of those were where the IPR was already far enough along that it had actually been instituted and not just a petition filed. So it certainly would be expected to have potentially some effect, but how significant effect it is not terribly clear. Permanent injunctions, and in particular, folks thought eBay v. Merck Exchange, the 2006 Supreme Court case, would significantly affect the ability to obtain injunctive relief. In that case, the Supreme Court held that the plaintiffs have to show that remedies at law are inadequate to compensate for that injury and that there's no presumption that patent infringement should be entitled to a permanent injunction. In fact, the data from a recent patent progress study indicates that it didn't really change the overall risk materially, that it was perhaps 89.1% for plaintiffs before eBay overall, But afterwards, the risk of a permanent injunction, once a patent's found to be valid and infringed, dropped, but not substantially, to 85.2%. The real change, the real effect was on non-practicing entities, where the study using the high-volume plaintiffs as a proxy for NPEs found that they were affected much more substantially. Basically, one-third reduction, I should say, in the number of permanent injunctions after eBay, and that in fact that's probably not as great as you might even expect, but the NPE requests dropped by almost 50%. So the number of requests dropped, and the number of successful requests dropped as well. So if you look at those in tandem, you find that it's really a substantial number of permanent injunctions, a substantial reduction in that number of permanent injunctions for non-practicing entities, and perhaps that's responsible for nearly all of the overall reduction in permanent injunction rates for plaintiffs as a whole. I attempted to reproduce this on Docket Navigator, and Docket Navigator, I came up with numbers more around the 75% range for success of injunctions, permanent injunctions after eBay, using the data that they had versus, I think, Lex Machina was the data the Patent Progress Study used. But still in all, it was not as huge of an effect for plaintiffs overall as I would have expected. Another risk with respect to not getting counsel involved, of course, remains the issue of inducement and, for that matter, contributory infringement. The Global Tech, the SEB case that I mentioned before, found that basically trying to hide information from their own attorney in rendering a freedom to operate opinion, a right to use opinion, was grounds for finding the willful blindness that was required for inducement, and would also be very strong evidence of willful infringement. So, as I said, under Section 298, the issue of failing to get a opinion of counsel is not going to be by itself grounds for finding willful blindness, but obtaining an opinion of counsel is certainly going to be strong evidence of good faith and the lack of willful blindness. So it still has a significant effect. And although Global Tech VSCB talks about inducement specifically and the willful blindness there, the Supreme Court also in that case mentioned contributory infringement, and that it too had this intent requirement. And so again, knowing Section 271C requires that you sell something that's especially adapted, knowing that it is especially adapted to infringe, and that knowing requirement, the intent, is something that could help you be ameliorated by having an opinion of counsel that provides a strong non-infringement argument. Willfulness. With respect to Section 284, once again, Section 298 says a opinion of counsel isn't mandatory, but but it's clear that it is still something that is strong evidence of good faith and lack of willfulness. There was a Supreme Court case in 2016, Halo Electronics, which substantially changed the bases, both the standard for proving up willfulness from clear and convincing evidence to preponderance of evidence. It substantially lowered it. But then it also changed the overall test for willfulness. Up until Halo, the Federal Circuit had tried to impose a fairly rigid, somewhat more predictable test that required not only proof of subjective evidence of willfulness, but also an objective standard, specifically that the defendant acted despite an objectively high likelihood that its actions constituted infringement of a valid patent. Well, the Supreme Court upended that with HALO and came out to say the subjective willfulness of patent infringer, intentional or knowing, may warrant enhanced damages without regard to whether his infringement was objectively reckless. And I do like this next quote from the Supreme Court. Variously, that willfulness is in the patent context has been variously described in our cases as willful, wanton, malicious, bad faith, deliberate, consciously wrongful, flagrant, or indeed characteristic of a pirate. I keep thinking of hoisting up the Jolly Roger. But the Supreme Court, tried to ameliorate a little bit this reduction of the standard by saying that the simplification of the standard to just subjective evidence, by saying that none of this is to say that enhanced damages have to follow from a finding of egregious misconduct, and there's some question as to how significantly that last caveat has really been applied by the courts, and we'll get into that in a little bit. But what is important to note is that the Federal Circuit doesn't ever like to leave well enough alone. They've actually tried to, in some ways, reimpose a somewhat more objective standard. The real problem with this subjective standard is it doesn't allow an accused infringer any way of avoiding trial on the case. It's very difficult to get summary judgment of no willful infringement under this subjective standard. It's very difficult to get JNOV to overcome a jury finding of willfulness, even when there isn't sufficient evidence. But in a recent Federal Circuit case, SRI International v. Cisco Systems, the Federal Circuit seized on this language, willful, wanton, malicious, bad faith, in order to, as I mentioned, reimpose sort of a more objective standard, and ended up rejecting a jury finding of willfulness, where they held the record was insufficient to establish the jury's finding that Cisco's product rose to the level of wanton, malicious, and bad faith behavior required for willful infringement. So Federal Circuit holds out a little bit of help, a little bit of light at the end of the tunnel, perhaps, for this HALO standard for defendants, but everyone has to realize that this substantially increases the risk of a finding of willfulness between the lower burden, the preponderance evidence versus clear and convincing evidence, and relying so much on subjective evidence as opposed to having the additional layer of objective evidence requirement. All of which, again, suggests, an attorney opinion at an early stage can significantly reduce the risks on the willfulness side. Another case, another issue is, of course, attorney's fees, finding of exceptional case under 35 U.S.C. Section 285. The issue here is that willfulness alone can be a sufficient basis for finding an exceptional case and attorney's fees. And in fact, there's a Federal Circuit case, Modine Manufacturing v. Allen, from 1990 that held this bullet point here about court must explain why case also not exceptional, that when a trial court denies attorney's fees in spite of a finding of willful infringement, the court must explain why the case is not exceptional within the meaning of the statute. So, again, the issue of willfulness is certainly front and center in connection with the issue of exceptional case and the risk of having to pay your opponent's attorney's fees. Now, Section 285, like Section 284, was upended by the Supreme Court. In fact, even before the HALO case with octane fitness in 2014, the Supreme Court again rejected an attempt by the Federal Circuit to impose a more rigid standard, an objective baselessness requirement to justify an award of attorney's fees, and also rejected the clear and convincing evidence standard that the Federal Circuit had tried to impose, instead leading to a preponderance of evidence. And the review standard instead, of course, with an award of attorney's fees, is going to be an abuse of discretion. Now, we took a look at how HALO and octane actually affected decisions on attorney's fees and enhanced damages. Thought it would be interesting, and not surprisingly, for willfulness, removing the objective evidence requirement and the clear and convincing evidentiary standard substantially increased the success rate of willfulness assertions from 36.6 to 63.5%. Interestingly, though, in connection with that, the rate of enhanced damage awards actually dropped from 70% to 67.6%. Of course, there were a lot more willfulness findings, so of those willfulness findings that actually led to enhanced damages, the overall number increased, but it didn't increase quite as much as one might have expected given the higher number of willfulness findings. Exceptional case, you'll also see a little bit of a divergence. Interestingly enough, due to octane, or at least with respect to octane, exceptional case findings actually dropped, the percentage-wise, 37.6 to 36.3% for all cases where an exceptional case finding was sought. But it's important to recognize that plaintiffs sought exceptional case findings twice as often after octane, and may well have sought it in situations where they weren't necessarily as entitled to exceptional case findings, which may be the reason for the slight drop in the percentage of success rates. And then attorneys' fees awards before octane were at 22.5% and did actually increase to 30.1%, which is roughly a one-fourth increase as a result of octane lowering the exceptional case standards. The last issue on opinions of counsel before I turn this over to Jason is that the timing of opinions. HALO made very clear that culpability is measured against the knowledge of the actor at the time of the challenged conduct. So any kind of opinion, it's really important to have that opinion as early as feasible, as promptly after learning of the patent and the risk of infringement as possible. The HALO court specifically criticized after the fact sort of rationalizations of infringing conduct, and from that perspective, it really ended up making it clear that the timing of the opinions and the promptness of the opinions is something that's very important. So, in any event, I'll turn this over to Jason, but before we do, I'm going to go back to this attendance tracking and the fact that you have to put in the polling box at your right of your screen opinion, the word opinion, if you indeed want CLE credit, and do not forget to hit submit. Thank you.
All right. We're running a little short on time for what I prepared to discuss, so I'm going to talk while this slide remains up. I'll leave it up for just a bit longer so that you all have an opportunity to enter the polling keyword here. So in the next section, we're going to talk about opinions of counsel, strategies, and some best practices and things to think about. there's a few different types of opinions that you can obtain to support a good faith basis for proceeding with a commercial product. Non-infringement opinion is similar to the analysis I was discussing earlier. It's an opinion that a product likely does not infringe one or more claims of a patent. An invalidity opinion is an opinion that claims of a patent would be invalid based on one or more provisions of U.S. patent law. And then the least common opinion is an unenforceability opinion. This is an opinion that the patentee defrauded the patent office during prosecution of the application that ultimately became the patent. And these are really reserved for more egregious scenarios of fraud, for example, withholding material information or making a false declaration, making some kind of false statement to the patent office. So the title of this slide that you're seeing now is Opinion Hierarchy. And the reason I've titled it that way is because all things being equal, it is generally preferred to have a non-infringement opinion over an invalidity opinion. And some of the reasons for that are that the standard of proof is more favorable for a non-infringement opinion, and the burden of proof is more favorable for a non-infringement opinion. So standard of proof for non-infringement is preponderance of evidence versus clear and convincing evidence for an invalidity opinion. So a patent goes through an administrative process. The patent office has examined it and made a decision that it is entitled to a patent. There's a presumption of validity. There's a higher standard to be able to invalidate that patent. The burden of proof for non-infringement is on the patentee. I should say the burden of proof is on the patentee for them to prove infringement. So the burden's on the patentee. With respect to invalidity, again, you've got an issued patent that's presumed valid, so the burden is on the accused infringer to establish invalidity. So for those reasons, all things being equal, you prefer non-infringement opinion over an invalidity opinion. But certainly there will be times when a relatively strong invalidity position may be preferred over a relatively weak non-infringement position. And these are not mutually exclusive either. You can have scenarios where it makes sense to have more than one type of opinion for a given patent. Maybe you have different claims that are covered by different opinions within a patent, or maybe you cover a single claim on both sides, non-infringement and invalidity. It's really a case-by-case scenario how you evaluate these types of issues. So opinions can come in a few different forms. Oral opinion is the lowest cost, the fastest. Those are some of the pros in favor of it, but really it's a relatively weak form of protection. As one court stated, an oral opinion carries less weight because they have to be proved years after the event based on testimony which may be affected by faded memories and forces of contemporaneous litigation. So, as you see here, there's some reliability problems. People forget the underlying rationale and why you arrived at the conclusion of the opinion. And of course, if employees leave, they take that knowledge with them. There's also some privilege concerns. So out of fairness, attorney work product privilege can be waived if all you're relying on is an oral opinion because there's no documentation. So the only documentation that may exist is the attorney's work product. And out of fairness, the court may allow discovery of attorney work product for an oral opinion. So there's some negatives to it, but there certainly is a place for oral opinions. For patents that are on that lower end of the spectrum in terms of risk, very low risk or no risk, an oral opinion might be a very reasonable decision. The risk of litigation is very low. Also, if you have a short timeline for launching a new product, an oral opinion could be a good idea to have prior to the product launch. However, you'll likely want to follow up with some form of a written opinion that lays out the underlying rationale as to the basis for the opinion. A formal opinion offers the strongest form of protection. Here you're going to do a thorough analysis of all the background information, the law, the facts. We'll talk a little bit more about that in the next few slides. The downsides are it's a little more costly and it's a longer time to prepare. But this is going to provide you the strongest form of protection. There's no question as to the basis for the conclusions in the opinions. In a deposition, so oftentimes the person who's relying on the opinion may be deposed. And having a formal written opinion that's thoroughly prepared provides them with the answers to the questions that are most likely to be Lastly, a formal opinion can add an aura of competency surrounding the opinion, so it can really help to establish the reasonableness and the good faith in reliance upon it. Now, I'll just briefly touch on informal written memorandum, but basically this is some written document that is similar to a formal opinion but may cut some corners. So you may omit a legal standards section, you may omit some detailed analysis of the file history, maybe you don't construe as many claim terms. Better than an oral opinion, not as good as a formal opinion. But, which type of opinion you proceed with may depend on a number of factors. For example, the relative risk being one of them. So this next slide here's some of the considerations that you might look into in determining whether to obtain an opinion or, like we just talked about, what type of opinion to obtain. So one important thing to consider is how much money is at stake. High revenue products, high margin, high volume products create a potential for large damages awards, as for the reasons Grant just discussed. And those are factors that may sort of steer you towards obtaining an opinion to protect against having to, to protect against those large damages. The amount of investment in development of a new product. So if you've sunk a lot of money into a new product, it may be well worth the investment in putting a little bit towards an insurance policy in the form of a freedom to operate analysis and an opinion, and going that extra step of doing the formal opinion to give yourself the best form of protection. Some other things you can consider: the competitiveness of the market. Do you have litigious competitors? What's the market share of competitors? Are you trying to enter a new market where people are more likely to want to keep you out? Do you have direct competitors that you're worried about? Those types of things. And then the last one here is risk tolerance. So every company is going to have its own level of risk tolerance. If you want to avoid risk at all costs, doing lots of opinions and going all out and doing formal written opinions is likely what you're going to proceed with. Higher risk tolerance, you might take more opportunities to do some of the other forms of opinions, or not write an opinion, which may not be advisable in most scenarios. But okay, so if we've decided to do an opinion, what's the goal of the opinion? We should remember that the goal of the opinion is not the actual correctness of the conclusion in the opinion. The goal is to provide the recipient with the good faith belief that in the opinion's contents and its conclusions. Again, we're trying to protect against willful infringement. We need to give them reasons that there's a good faith belief that they can practice their product, have their product out in the marketplace, and not be infringing someone's valid patent. So how do we achieve this goal? The opinion should be objective. Objectivity is essentially tantamount to reliability. It should be objective in tone. You're not just telling the client what they want to hear. The client may be your audience initially, but at some later stage, if the opinion is an issue, you're really speaking to the judge or the jury as well. And then thoroughness and competency we can cover in some of these other slides. Okay, so what are some hallmarks of a quality opinion? It should address all claims in the patent on the basis of at least one of non-infringement or invalidity. So if you infringe one claim, you infringe the patent, you're subject to liability. You want to make sure you're considering all the claims in the patent on at least one of these bases. Now, you might not prepare an opinion on all claims if, for example, you have some claims in a patent that's on that lower end of the spectrum where there's really no good faith basis for an infringement analysis. Another hallmark of a quality opinion, it makes clear that everything that, you really considered everything in reaching your conclusion. It's a well thought out, well-reasoned opinion. You do an evaluation of the product, the patent, the file history, and the prior art. This all helps to establish, that your conclusion was thorough and thoughtful, and that it really helps to support the good faith reliance upon the opinion. Okay, demonstrates proper understanding of application of legal principles. Here, you want to make sure that all your case law, your legal citations is good law. In an opinion, you lay out the facts in an objective manner. You lay out the applicable legal standards, and then you apply the law to the facts. You need to make sure you're applying the correct law and that you correctly understand it. That creates problems if you're not doing that. It creates you could have a problem where your opinion is essentially it was unreasonable to rely upon it if you're not citing the right law or applying the right law. And lastly, you want to make sure you're construing all the claims in accordance with Phillips. It's not good enough to just say ordinary meaning, plain meaning. You got to look at the intrinsic evidence and use it to support your conclusion. Okay, in the interest of time, we're going to skip this one because I don't want to run too far over. Let's go to the next one, which is what makes for a good non-infringement opinion. We've talked a little bit about this, but you want to have an accurate product description. You need to make sure that you have an accurate product description, otherwise your analysis falls apart right at the start. You should avoid using terminology from the patent claims where possible, so you don't create any presumptions that you're admitting, any admissions of a patent limitation being in the product. So that's when reasonable. A couple other points: you should make sure that your product description is consistent with the way you've described your product in other places. So, for example, marketing materials, 510K filings. There's another bullet point, 4 down, positions taken in your opinions that are consistent with positions during prosecution. So again, if you're characterizing a patent in a certain way or a prior art document, you want to make sure that you're consistent in how you're characterizing it. You can't have it both ways. You can't interpret something one way to avoid infringement and then interpret it another way to secure a patent. Lastly, real quick, you want to make sure you address the doctrine of equivalence for non-infringement. A lot of non-infringement opinions fall down by failing to consider doctrine of equivalence. Okay, so what makes for a good invalidity opinion? You should really consider the hierarchy of grounds for invalidity. Depending on the technology area, 101 may be a particularly strong grounds for invalidity if you're in, for example, business method area, technology areas. But you can see here, 102 is preferred over 103. You don't have the extra step of providing a KSR analysis for when you're looking at 102. 112 and double patenting issues are more of secondary bases. You really want to have a 101, 102, or 103 grounds first, and then these are kind of nice to have. Hierarchy of prior art. You're better to have prior art not considered by the examiner versus prior art that was. So to the extent possible, you can use that, avoid the presumption of validity. Include more than just a claim chart. So if it's just a conclusory opinion, just a collection of parts and found in the prior art, that's not as good as a thorough analysis. Especially in the case of 103, you need to provide a KSR analysis and explain why it would have been obvious to combine different teachings to arrive at the patent claim that you're invalidating. Okay, so again, just emphasizing, you want to make sure your positions in these opinions are consistent with positions taken in your own prosecution of your own applications. You can't have it both ways. And you want to coordinate with your patent prosecution counsel on some of these issues to make sure you're doing that. Okay.
All right. Well, we are there is more for us to discuss. Frankly, we could probably take up another hour of discussion and answering questions. We will send you a link to the presentation. As we mentioned, there'll be a transcript as well, and we will get back to you on each of your individual questions as well. Thank you very much for participating, and I hope you found this useful.